Chandrakant sir. Chandrakant sir.
Yes, I'm Chandrachud.
Sir, please enable the camera once.
Enable camera.
Yes, sir.
Yes.
Fine, sir. Please enable the camera when your item begins, sir. Thank you so much.
Thank you. Thank you.
There are 4 opinions in the case. I've authored the majority opinion for Justice Sanjeev Khanna, Justice Jamshed Padiwala, Justice Manoj Mishra, and myself. There are 3 dissents. Justice Suryakant has written a separate opinion. Justice Dipankar Datta has written a separate opinion. Justice Satish Chandra Sharma. They've each authored their own opinions. So it's 4-3. I'll read out just a few pages. The petitioner and the respondents disagree on whether this bench must determine if AMU is a minority educational institution. In Anjuman-e-Rahmaniya, the 2-judge bench referred the question of the essential ingredients of a minority education institution. This was the core issue which was referred to the Constitution bench. The other 2 questions which were formulated, that is the meaning of the phrase established and the impact of registration under the Societies Registration Act 1860 after the establishment of the institution, are in a sense subsets of the core issue. The question of the indicia for recognizing an educational institution as a minority educational institution was reflected in question 3A framed in TMA Pi. Thus, neither was Anjuman-e-Rahmaniya nor TMA Pi concerned with the factual situation in Aziz Basha, that is whether AMU is a minority educational institution. The 2019 reference order also limits the reference to the legal aspects arising from the decision in Aziz Basha and not the factual aspects of the decision relating to AMU. This is clear from the passages from the 2019 reference order extracted above, particularly paragraphs 8 and 9. Paragraph 8 states that the correctness of the question arising from Aziz Basha has remained undetermined. The paragraph indicates that the 2019 reference order must be read along with the previous references in both Anjuman and TMA Pi Foundation. Paragraph 9 mentions that the correctness of the views in Aziz Basha, which has been extracted above, requires an authoritative pronouncement. The paragraph from Aziz Basha extracted in the 2019 reference order deals with the question of the indicia to be considered a minority education institution. It is thus evident upon a reading of the reference orders that the question of the criteria to be fulfilled to qualify as a minority educational institution is referred to this bench. From the order in Anjuman-e-Rahmaniya, referring the judgment in Aziz Basha to a larger bench, the question formulated in TMA Pi and the 2019 reference order, the question that must be decided by this bench is what are the ingredients, indicia, or criteria for an educational institution to be considered as a minority educational institution under Article 30. The following issues must be answered for this purpose. A, whether an educational institution must be both established and administered by a linguistic or religious minority to secure the guarantee under Article 30. B, what are the criteria to be satisfied for the establishment of a minority institution? Whether Article 30, bracket 1, envisages an institution which is established by a minority with participation from members of other communities. C, whether a minority education institution which is registered as a society under the Societies Registration Act 1860, soon after its establishment, loses its status as a minority education institution by virtue of such registration. And D, whether the decision of this court in Professor Yashpal versus State of Chhattisgarh and the amendment of the National Commission for Minority Educational Institutions Act 2005 in 2010 have a bearing on the question formulated above, and if so, in what manner? Doubting the correctness of the opinion in Aziz Basha, without disagreeing with it, the 2-judge bench in Anjuman-e-Rahmaniya requested that the matter may be placed before the Chief Justice of India for being heard by a bench of 7 judges. This falls within the permissible limits laid down in Central Board of Dawoodi Bohra Community, as explained in point B of paragraph 37. Further, the learned Solicitor General has also stated that he is not pressing the union's preliminary objection. The order of reference dated 12 February 2019 too noted that although a 3-judge bench could not ordinarily refer a case directly to a 7-judge bench, it was doing so in this case because the question has already been referred to a bench of 7 judges but was not answered. It cannot be disputed that Article 30 guarantees the minority education institutions the right to not be discriminated. In fact, Article 32 is a facet of the principle of non-discrimination of minorities. The article provides that the state shall not discriminate in granting aid to educational institutions or discriminate on the ground that it is under the management of a religious or linguistic minority. The question is whether the use of right in Article 30, bracket 1, also guarantees a special right in addition to the right to non-discrimination. Until the judgment of the 11-judge bench in TMA Pi, the right to establish and administer educational institutions was interpreted as a right that was exclusively available to religious and linguistic minorities by virtue of Article 30. In TMAPI, the right of every citizen to establish and administer educational institutions was traced to Article 19(1)(g), which guarantees the freedom to practice any profession or to carry on any occupation, trade, or business. The 11-judge bench also traced the right of every religious denomination of both the majority and the minority to establish and administer educational institutions to Article 26A, which guarantees the right to establish and maintain institutions for religious and charitable purposes. Charitable purposes were interpreted to include education. The rights guaranteed by Articles 19(1)(g) and 26A can be reasonably restricted on the grounds in Articles 19(6) and 26 respectively. An educational institution established and administered by any citizen can be regulated on the grounds stipulated in Article 19(6), which includes the ground of professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. An educational institution established by a religious denomination without any element of profit can be regulated on grounds of public order, morality, and health. As opposed to these two provisions, Article 30 does not circumscribe the right on any grounds. This court has, however, consistently emphasized that the right guaranteed by Article 30 is not absolute. In State of Kerala versus Reverend Mother Provincial, the six-judge bench differentiated between restrictions on the autonomy of a minority institution and the standard of education. The former is impermissible in view of the protection under Article 31. The latter was traced to the regulation of the profession, which is covered by Article 19(6). Thus, regulation of a minority educational institution is permissible on the grounds in Article 19(6). However, the regulation must not infringe the minority character of the educational institution. Article 31 is absolute in that sense. Regulations that may be justified on the grounds stipulated in Article 19(6) and 26 may fall foul of Article 30 if they infringe the minority character of the institution. This is the special right or protection which the Constitution guarantees minority education institutions. This special right is a guarantee of limited state regulation in the administration of the institution. The state must grant the minority institution sufficient autonomy to enable it to protect the essentials of its minority character. The regulation of the state must be relevant to the purpose of granting recognition or aid, as the case may be. This special or additional protection is guaranteed to ensure the protection of the cultural fabric of religious and linguistic minorities. This court in Aziz Basha held that the words establish and administer must be read conjunctively. That is, the guarantee of the right to administration is contingent on the establishment of the institution by religious or linguistic minorities. The question is whether the conjunctive reading of the words establish and administer would also mean that for an educational institution to be a minority institution, it should have been both established and administered by a minority. In Aziz Basha, the Constitution bench held that the institution must be both established and administered by the minority. Article 31 cannot extend to a situation where the minority community which establishes an educational institution has no intention to administer it. A religious or linguistic community may establish an educational institution and yet not administer it. This is evident from Article 28(2), which states that Article 28(1) will not apply to an educational institution which is administered by the state, but was established under an endowment or a trust which require religious instruction to be imparted. It is quite possible that a member or a group belonging to the minority community wishes to establish an institution, but intends to accept greater state regulation and lesser autonomy for the community. In that sense, putting a minority tag on such an educational institution merely because it has been established by a person or group belonging to a religious or linguistic minority would not be permissible under Article 31. An educational institution established by a minority, whether linguistic or religious, can give up their right to claim the benefit of Clause 1 of Article 30. The right can be given up consciously by waiver. This may occur where administration has been consciously and willingly entrusted to the state. Therefore, to determine whether an educational institution is a minority educational institution, a formalistic test, such as whether it was established by a person or group belonging to a religious or linguistic minority, is not sufficient. The test adopted must elucidate the purpose and intent of establishing an educational institution for the minority. Both the establishment and the administration by the minority must be fulfilled cumulatively for that. A distinction between educational institutions established before and after the commencement of the Constitution cannot be made for the purposes of Article 31. Article 30 will stand diluted and weakened if it is only to apply prospectively to institutions established after the commencement of the Constitution. What is the scope of Article 30 when read in the context of Article 372 read with Article 13? Any law enacted by the imperial legislature which discriminates against linguistic and religious minorities in the establishment and administration of educational institutions would be void. This is the scope of the provision vis-a-vis Articles 372 and 13, when Article 30 is purely read as a negative right. But this court has also interpreted the article as a special rights provision, guaranteeing additional protection to educational institutions established by minorities. Thus, educational institutions established by religious and linguistic minorities before the commencement of the Constitution will also receive the special protection guaranteed by Article 30, the right to administration without the infringement of their minority character. Could it be argued that a university was established by the legislature merely because it enacted a legislation incorporating it? The words incorporation and establishment cannot be used interchangeably. They connote different things. Incorporation signifies the legal existence of the institution. In contrast, establishment signifies the founding or bringing into existence of the institution. The possibility of distinguishing the establishment and incorporation of universities arose with the advent of teaching universities. Two kinds of institutions were incorporated as teaching universities. They consisted of institutions which were established and incorporated at the same time, and institutions in which the establishment of the institution predated its incorporation. Universities in the latter category, however, were teaching colleges converted into teaching universities. The establishment and incorporation of these universities was distinct. The instance of conversion of teaching colleges to teaching universities elucidates the distinction between the establishment and incorporation of educational institutions. The word establish, as used in Article 31, cannot and should not be understood in a narrow and legalistic sense. The words used in Clause 1 of Article 30 have to be interpreted in view of the object and purpose of the article and the guarantee and protection it confers. It cannot be argued that a university was established by Parliament merely because the long title and preamble of the statute incorporating the university states that it is an act to establish and incorporate. If such a formalistic interpretation is adopted, fundamental rights would be made subservient to legislative language. The courts must identify the circumstances surrounding the incorporation of the university, including a thorough reading of the statute, including through a reading of the statute, to identify who established the university. Formalism must give way to actuality and to what is real. The right under Article 31 is guaranteed to minorities as defined upon the commencement of the Constitution. A different right-bearing group cannot be identified for institutions established before the adoption of the Constitution. To determine who established the Constitution, the courts must consider the genesis of the educational institution. For this analysis, the courts must trace the origin of the idea for the establishment of the institution. The court must identify who was the brain behind the establishment of the educational institution. Letters, correspondence with other members of the community, or with government or state officials, and resolutions issued could be valid proof for establishing ideation or the impetus to found and establish. The proof of ideation must point towards one member of the minority or a group from the community. The second indicia is the purpose for which the educational institution was established. Though it is not necessary that the educational institution must have been established only for the benefit of a religious or linguistic minority community, it must predominantly be for its benefit. It is not necessary that education must be provided in the language spoken by the minority or in the religion of the minority. The indicia could be proved by a reference to private communications or speeches about the necessity of establishing an educational institution for the community and a recognition of the educational difficulties faced by that community. The third test is tracing the steps taken towards the implementation of the idea. Information on who contributed the funds for its creation, who was responsible for obtaining the land, and whether the land was donated by a member of the minority community or purchased from funds raised by the minority community for this purpose, or donated by a person from some other community, specifically for the establishment of a minority educational institution, are elements that must be considered. Similar questions must be asked of its assets. The next question is whether the administrative structure of the educational institution is an indicia for the establishment of a minority educational institution. We have already held above that an educational institution is a minority educational institution if it is established by a religious or linguistic minority. We have clarified that it is not necessary to prove that administration rests with the minority to prove that it is a minority educational institution, because the very purpose of Article 31 is to grant special rights on administration as a consequence of establishment. To do otherwise would amount to converting the consequence to a precondition. The right to administer is guaranteed to minority educational institutions to enable them to possess sufficient autonomy to model the educational institution according to the educational values that the community wishes to emphasize. It is not necessary that the purpose can only be implemented if persons belonging to the community helm the administrative affairs. This is so particularly because a minority institution may wish to emphasize secular education. The test to be adopted by the court is whether the administrative setup of the educational institution affirms the minority character of the institution. If the administrative structure of the educational institution does not reflect its minority character, or when it does not elucidate that the educational institution was established to protect and promote the interests of the minority, it may, however, be reasonably inferred that the purpose was not to establish an educational institution for the benefit of the minority community. We may specifically deal with a scenario of an educational institution established before the commencement of the Constitution. The test of administration should be evaluated in presenti, that is, on the date of the commencement of the Constitution. An institution to be a minority institution must satisfy the criteria of being administered as a minority institution on the date of the commencement of the Constitution and being a minority institution on the date of formation. Even if an educational institution was established by the minority for the purpose of the community, we must assess the impact of any subsequent events that alter the character of the institution before the commencement of the Constitution. The court may, on a holistic reading of the statutory provisions relating to the administrative setup of the educational institution, deduce if the minority character of the purpose of establishment was relinquished upon incorporation. The question is whether the regulatory measures wrest the administrative control from the founders of the institution. This is a question of fact, which must be determined on the facts of each case. The court must make that determination upon a comprehensive analysis of the administrative framework, which includes a host of factors, such as the representation of the interests of the community in the administrative setup. The above indicia must be proved through the submission of cogent material. Reliance must be placed on primary sources such as office documents, letters and resolutions, or memorandums issued to implement the resolution. Secondary sources must be only used to corroborate the primary sources. The onus to prove that the educational institution was established by a minority is on the claimants. The view taken in Aziz Basha that an educational institution is not established by a minority if it derives its legal character through a statute is overruled. The question of whether AMU is a minority educational institution must be decided based on the principles laid down in this judgment. The papers of this batch of cases shall be placed before the regular bench for deciding whether AMU is a minority educational institution and for the adjudication of the appeal from the decision of the Allahabad High Court in Malay Shukla's case after receiving instructions from the Chief Justice on the administrative side.
In my opinion, I have said that a three-judge bench presided by the Chief Justice of India, wide order dated 12 February 2019, passed in Aligarh Muslim University versus Naresh Agarwal, made this reference to a bench of 7 judges with a view to determine the correctness of the question arising from the decision of this court on Aziz Basha, which had ruled against the minority status so to be accorded to AMU. Second, to determine question 3A formulated in TMA 5. And third, whether the decision of this court in Professor Yaspal versus Chhattisgarh State of Chhattisgarh and the amendment in 2010 in National Commission for Minority Education Institute Act 2004 have any bearing on the aforesaid question formulated. The fulcrum of this reference rolls around the interpretation of Article 30 of the Constitution of India, which deals with the right of minorities to set up education institutions. We have had the benefit of perusing the erudite majority opinion authored by Honorable the Chief Justice Dr. D.Y. Chandrachud. While the said opinion comprehensively addresses each issue with depth and clarity, we have expressed a differing view on the interpretation of certain aspects given the significant constitutional implications involved. Recognizing the weight of these issues, we have chosen to offer our own perspective, though we acknowledge the thoroughness and diligence with which Honorable Chief Justice has approached this complex matter. Before we lay down the indicia under Article 30 to determine whether an institution has a minority character and ought to be afforded protection, we deem it appropriate to embark on a substantive analysis of the issues involved and will begin by undertaking a comprehensive examination of the multifaceted nature of minority rights both in India and internationally. Then after discussing the international and within India how the minority rights have been developed and established, then I have referred to the constitutional scheme which ultimately led to formation of Article 29 and 30. Then we have explained the statutory scheme of National Commission for Minority Act 1992 and other relevant statutes having any bearing. Thereafter, I have referred to the brief history of AMU and followed by the features of the AMU Act 1920. Of course, for the reasons which I have assigned later on, these provisions we have not interpreted at this stage. We have only highlighted that what was the statutory scheme. Then we have explained the challenge to the constitutionality of the 1951 and 1965 Amendment Acts in the AMU Act of 1920 and the contentions which were raised in Aziz Basha when these amendments came to be challenged. After taking notice of the rival contentions which were raised before the five-judge bench in Aziz Basha, then we have also briefly culled down the conclusions drawn by this court in Aziz Basha. After that, we have given the history of discordance with Aziz Basha. There we have said, having analyzed Aziz Basha, it is imperative to also take account the decisions proffered by this court in other relevant cases to holistically understand the background of the reference before this court. Then, after referring to the 1972 amendment in the 1920 Act, we have referred to thereupon the first discordant note was struck by a two-judge bench of this court in Anjuman. That was a case where the court was considering the minority status of an institution established by a society registered under the Society Registration Act 1860. The question raised therein pertained to whether such registration would be determinative against the minority status of this institution. In this regard, then two questions were formulated that we have reproduced. And after discussion, we have said that almost 2 decades after the reference in Anjuman came the magnum opus decision of the 11th judge bench in TMA Pi. In this case, the court was tasked with analyzing the different facets of Article 30. Then question 3A, which was not answered in TMA Pi, is reproduced. Then after giving history that how the Anjuman was also disposed of, we have referred to the contentions raised in the present case on both sides, the appellant side as well as the respondent side. And after that, we have notified the issues which arise for determination. There we have said, thus in our considered opinion, the instant reference based on the question of the test required to be fulfilled by an institution for seeking protection under Article 30 of the Constitution of India can be broken down into following segmented questions of law and fact. The first prefatory issues are, what are the requisite parameters of reference to a larger bench? What matters were intended to be addressed by the larger bench in Anjuman? What are the facets required to be considered by a regular bench of making a reference is made to a larger bench? What are the powers entrusted to the Chief Justice of India in such circumstances? The second question is whether appellant has the locus standi to bring the present challenge. On the constitutional interpretation, the questions which you have formulated are, what are the tests to seek protection under Article 30 of the Constitution? And what is the meaning of the term established in Article 30? Next is, what is the meaning of the term administered in Article 30? whether AMU satisfy the test of establish and administer and is thus entitled to the protection of Article 30, whether the Union of India is obligated to defend the AMU Amendment Act 1981. On the prefatory issue of that what are the requisite parameters of reference to a larger bench, I have opined that the issue concerning the power of a regular bench to refer a matter to a larger bench must be examined in light of the order passed in Anjuman, which opined that Aziz Basha required reconsideration by a larger bench and proceeded to refer it to a 7-judge bench. To this end, the respondents have vehemently contended that such a reference was bad in law and should be declared so. In this vein, we have identified two key aspects of the issue. One, what are the issues identified in Anjuman which are intended for the larger bench to address, and two, whether the manner of making such a reference was legally sound. On the first part, we have said it is crucial to determine whether the bench in Anjuman intended to restrict the reference in such a way that the 7-judge bench would only analyze the criteria necessary for an institution to qualify as a minority institution under Article 30 of the Constitution. For the sake of clarity and despite the risk of repetition, we find it essential to put forth the relevant aspect. Then again, we have reproduced the reference order and then explained a plain reading of these observations revealed that the 2-judge bench in Anjuman doubted the correctness of the decision Aziz Basha and the principles enunciated therein. The bench, while questioning the holding of Aziz Basha, also borrowed strength from the views expressed by some jurists. In Aziz Basha, the issue pertained to the constitutional validity of AMU 1951 and 1965 Amendment Act. While questioning the correctness of the decision Aziz Basha, it is evident that the reference in Anjuman also insinuated that potential errors may have occurred in the analysis of the constitutionality of those enactments. The reference seeking to reopen the issues settled in Aziz Basha thus necessarily mean not only to re-examine the correctness of that decision, but also an attempt to revisit the constitutionality of the AMU 1951 and 1965 Amendment Acts. Importantly, the key term used in the reference order in Anjuman is "and," which is clearly used to state that both Aziz Basha's case may also be considered, and second, the ingredients of a minority institution should be examined definitively. Such an analysis would also have to consider the question posed in TMA Pi under 3 sub A regarding the criteria required for an institution to qualify as a minority institution under Article 30 of the Constitution, and consequently as to whether AMU fulfills such criteria or not. We therefore find it difficult to align ourselves with the opinion expressed by the majority led by Honorable Chief Justice, according to which the reference before us was limited to determining only the criteria an educational institution must meet under Article 30 of the Constitution. However, given the Honorable Chief Justice decision to further refer the matter pertaining to AMU to a regular bench, we have confined our views to discerning the relevant indicia under Article 30 so as to avoid binding or influencing the regular bench that will ultimately decide the factual issue. Then on the question of manner of making reference to a larger bench, we have said the 2-judge bench in Anjuman, after expressing doubt about the correctness of Aziz Basha and its principles, referred the matter for reconsideration to a larger bench. Additionally, the bench in Anjuman specifically stated that the larger bench reviewing Aziz Basha decision by a 5-judge bench should consist of 7 judges. The decision further directed that the matter be placed before Honorable Chief Justice for appropriate directions. Such a reference, to our mind, is not consistent with the established norms of judicial propriety. There are several reasons which substantiate this school of thought. For instance, Order 7 Rule 2 of the Supreme Court Rules 1966 as applicable during the time of the reference was made. We have reproduced the rule. In this regard, it is imperative to refer to the findings of the Constitutional Bench in Central Board of Daud Bohra Community, that subsequent Constitutional Bench, which while adjudicating the correctness of previous decision on the Bombay Prevention of Excommunication Act also laid down pertinent principles on the procedure of making references. The decision in Daud Bohra essentially clarified the framework concerning how a reference should be made, particularly when a bench of lesser strength doubts the correctness of a decision by a larger bench or co-equal bench. After referring to Daud Bohra, we have said the principles enunciated in Daud Bohra reinforce the provisions of the Supreme Court rules referred to earlier and also reiterate the well-established principles based upon doctrines of predictability, consistency, finality, and the principle of stare decisis. The 2-judge bench in Anjuman ought to have understood and applied the law consistent with these principles. The 2-judge bench in Anjuman, being of lesser strength than the 5-judge bench in Aziz Basha, lacked the authority to explicitly question the correctness of Aziz Basha and refer the matter to a 7-judge bench. In Anjuman, the bench not only referred the matter but also specified the numerical strength of the bench to which it should be referred. with a further direction that the matter be placed before the Chief Justice for the limited purpose of notifying the composition of the 7-judge bench. With utmost respect at our command, we do not appreciate as to how a 2-judge bench could dictate its viewpoint to the Chief Justice of India. Thus, to our mind, effectively impaired the Chief Justice authority as the master of the roster. Allowing such a practice would enable benches of lesser strength, such as a 2-judge bench, to undermine the decision of larger benches, potentially even as 11-judge bench. This would also place the Chief Justice of India in an untenable position, which would be bound by a judicial order, who will be bound by a judicial order, which, while acting in an administrative role, leading to procedural complications and embarrassment. We reiterate that such action completely undermines the principles of stare decisis, a well-established doctrine that mandates the consistent application of legal principles once pronounced by authoritative courts. This principle is rooted in the idea that once a court has determined a rule applicable to a specific set of circumstances, it should be followed in all future cases. After that, we have explained the principles which govern this issue, and we concluded we thus have no hesitation in holding that it is the Chief Justice of India alone who is the custodian of the authority to determine the composition of benches and the public, in public or national interest, place a matter before any bench he deems appropriate, even in the absence of any reference. That being so, now we have said that 2019 reference order, which was by a 3-judge bench, which included the then Chief Justice of India, cannot be faulted. Consequently, based on that order, we consider it appropriate to proceed with the determination of some of the issues concerning the constitutional challenge. We also respectfully disagree with the majority opinion authored by Honorable Chief Justice in paragraph 39 of his draft judgment, according to which Anjuman has merely doubted and not disagreed with Aziz Basha. It seems to us that the term doubt and disagree broadly carry similar connotations. It is difficult to doubt a judicial opinion unless we disagree with the correctness of the contents and substance. Similarly, a disagreement would originate only when such opinion is shrouded with doubts on law or on facts. Then, after explaining these principles, of course, as we have said that the 2019 reference was maintainable because that was a bench presided by Honorable Chief Justice. In conclusion, while fundamental rights cannot be applied, now before that, we have explained the locus of the pre-constitutional institution, that we have held that appellant is entitled to, the pre-constitutional institutions are also entitled to seek protection of Article 30. The conclusion drawn in this regard is, in conclusion, while fundamental rights cannot be applied retrospectively to disrupt pre-constitutional practices, the appellant is not barred from asserting a claim under Article 30 as long as the necessary conditions of this provision are met. Individuals or institutions who qualify to be protected through a fundamental right as of 26 January 1950 are entitled to enforce these rights under Article 32. Therefore, the appellant's locus standi cannot be dismissed on this basis. Now, on the question, we have said, as regard to the fundamental right claimed by the appellant, we have said, based on the foregoing discussion, we believe that the right ensconced under Article 30 belongs to the second category, namely, it is granted to a minority community at large, but can be exercised by an individual or a group of individuals. There was an objection whether writ petition at the instance of individual was maintainable. This right does not fit into the first category because Article 30 specifically aims to uplift and protect certain minority communities, making membership in such a community a necessary precondition. At the same time, however, it is also distinct from the third category because the protection envisaged in Article 30 is toward individual belonging to such a community and not the entire community as one single entity. Thus, while the rights exist for the benefit of the whole community, it can be exercised by its individual members rather than requiring collective action by the whole community. That issue also stands decided in favor of the appellant. Now, coming on the question of interpretation of Article 30, we have held that since the term "and" has been consciously employed instead of "or," it is clear that the text of the provision itself envisages the conditions to be read consecutively. To hold to the contrary would require reading down an original provision of the Constitution, which the court must refrain from doing. Considering that institutions claiming any benefit under Article 30 must satisfy this two-pronged test, it is right to say that the terms establishment and administration under Article 30 are conjunctive. After that, we have held Hence, while the parties are right in pointing out the relevant factors of genesis and the statutory sanction, the analysis of who established the education institution has to go beyond them to cover all aspects holistically. Since these factors would be a question of fact that would differ from case to case, giving a laundry list of all such aspects would be erroneous in law. However, to determine whether the minority community has established the institution or not, a few illustrative factors that the courts have considered in the past may include. Then we have highlighted certain instances where the courts have rejected or accepted the claim based upon, and those findings we have illustratively referred to. About UGC Act, we have said the NCME Act or UGC Act and Professor Yaspal are also not in, there is no discordance between them and the Aziz Basa. To that extent, we have said Aziz Basa holds to the contrary deserve to be. Only one aspect we have concluded about Aziz Basa. It seems to us that when the UGC or colonial laws mandated universities to be created by statutes, those who intended a university, including the minority community, were not absolved from complying with other relevant factors so as to bring the university into being. We therefore do not find any conflict between the amended provisions of the NCME Act, UGC Act, and the holding in Professor Yaspal. Each holds its own independent and distinct field and operates validly within their sphere. The minority community thus can establish a university under Article 30, provided it fulfills the norms of the UGC that gets legal sanction to create the university through a statute. To that extent, Aziz Basa holds to the contrary, it deserves to be modified and clarified. Then we have said to conclude the discussion on the meaning of established for an institution to fulfill the establishment prong under Article 30, it is necessary for it to have been brought into existence by the minority community and must be working toward the benefit of that community. Another conclusion on administration is, to this end, the very concept of administration is inherently fluid and a specific definition is likely to be under-inclusive. Determining whether a minority community exercises control over an institution is a factual question that varies from case to case. Although there is no definitive test to ascertain whether administration lies with the minority community, various judicial precedents provide indicators that may be considered relevant. Then on an illustrative basis, we have referred to those indicators which have been followed from time to time. And ultimately, we have said, to summarize, the test for administration under Article 30 involves identifying who holds effective and overall control within the institution. While external authorities may assist in its administration, the decisive influence and the control must rest with members of the minority community. To meet this test, the minority community must exercise both active and reactive control, ensuring that the administrative powers are genuinely held in both de jure and de facto terms. On the question of Union of India, whether it should challenge or support the amendment, we have said this question is ultimately only academic. Then we have identified the areas of divergence with the majority opinion. In light of the above discussion, we find ourselves at variance with the majority opinion authored by Honorable Chief Justice of India on the following issues. One, whether the opinion of 7-judge bench in Kerala Education Bill, while according to Honorable Chief Justice, was followed by a 6-judge bench in Siddhasbhai Sabhai, has been overlooked in Aziz Basa. There we have explained that in Kerala Education Bill, this court in no uncertain terms opined that there is no reason why the benefit of Article 31 should be limited only to the education institutions established after the commencement of the Constitution. The language employed in Article 30 is wide enough to cover both pre-Constitution and post-Constitution institutions, and that Article 30 gives two rights to the minorities, namely to establish and to administer education institutions of their choice. The right to administer obviously cannot include the right to maladminister. The minority cannot surely ask for aid or recognition of an education institution run by them in unhealthy surroundings, etc. In Siddhasbhai, the challenge was laid to a government order directing that 80% of the total number of seats in non-government training colleges should be reserved for school board teachers deputed by the government. What comes to light in Siddhasbhai is that the bench therein did not rely upon the opinion delivered by the 7-judge bench in Kerala Education Bill, and rather distinguished it as the latter was relied upon by the state. The Constitutional Bench in Siddhasbhai thus took pains to explain that the opinion in Kerala Education Bill was distinguishable and that it is not an authority for the proposition submitted by the Additional Solicitor General that all regulative measures which are not destructive of the character of the institution established by the minority, provided the regulations are in the national or public interest are valid. We now turn to examine whether the 5 judge bench in Aziz Basa failed to follow the principles opined in Kerala Education Bill or those laid down by the 6th judge bench in Siddhas Bai. Insofar as Kerala Education Bill is concerned, Aziz Basa categorically holds that the protection of Article 31 was not restricted only to education institutions established after the Constitution came into force. Such a restrictive interpretation was held to be contrary to the opinion delivered in Kerala Education Bill and was bolstered with strong language that if that interpretation was given to Article 31, it would be robbed of so much of its content. The bench further held that the expression established and administered must be read conjunctively in response to a plea that even if an education institution was not established by minorities, it could still be administered by those under the ambit of Article 30. This view, which has been consistently affirmed in the later decisions as well, in our considered opinions, is the correct interpretation of Article 31. As regard to Siddhas Bai, it was neither cited nor was particularly relevant in the context of the controversy that arose for consideration in Aziz Basa. Most pertinently, the decision in Siddhas Bai is no longer a good precedent to the extent of disapproval of its view by 11th bench in TMA Pai in this regard. We therefore see no accordance between Kerala Education and Siddhas Bai on one hand and Aziz Basa on the other. On the second point where we have not been able to find ourselves in agreement is whether there is any conflict between Aziz Basa and the principles enunciated in TMA Pai. On a cogent reading of paragraph 106 to 108 of the draft judgment circulated by the majority, gives an impression that Aziz Basa had some collision with the subsequent 11th question bench in TMA Pai. In this regard, a reference has been made to paragraph 70, authored by Honorable Justice Kirpal, as his lordship then was. We are, however, unable to find any such perceived conflict between the two decisions. TMA Pai considered the scope of regulating the right of administering government-aided private minority institutions from paragraph 82 onwards. Then we have reproduced para 93 of TMA Pai, and after discussion, the answer given in para 107 of the TMA Pai. It may thus be seen that the decision in Siddhas Bai, which hold that the fundamental freedom under clause 1 of Article 30 is absolute in terms, if not made subject to any reasonable restriction, has not found favor and has been expressly disapproved by TMA Pai. On the question of 2 judge bench, whether competent to make a reference, as already explained, we have again reiterated that such a reference could not be made. Further, there is no substantial difference between doubting or a larger bench or disagreeing with such judgment. Doubt and disagreement both originate from a template opinion, which is in conflict with reasons already assigned by the larger bench. There cannot be disagreement without doubting the correctness, and there cannot be a doubt unless disagree with the reasons. Most importantly, entertaining a reference by 2 judge bench doubting a larger bench would dilute the authority and position of the Chief Justice of India as enjoyed upon under Article 145, read with the Supreme Court Rules 1966, as were then applicable. Then what is the true import of entry 63 of list 1 of the Constitution? We have explained entry 63 in 2 parts, first part and second part. As regard to the first component of entry 63 is a substantive part, which is a constitutional declaration of BSU and AMU to be institutions of national importance. The opening part of entry 63 manifestly indicates that the Constituent Assembly was determined to confer such an elevated status on both BSU and AHU. The second component of entry 63, on the other hand, permits the Parliament to declare any other institution also to be an institution of national importance. It seems from the language of entry 63 that the Parliament has no power to take away the status of an institute of national importance conferred upon BSU or MU, save and except by following the route of an amendment to the Constitution itself. But we have said route of Article 246 can be followed for the purpose of declaring any other institution as an institution of national importance. Having delineated the issues of disagreement with the majority opinion, we may hasten to add that one of the conclusions assigned in Aziz Basa is such that it deserves to be revisited. We say so for the reason that then we have explained, as already pointed out, our conclusion is that to the extent it, and I will just read that part, in this context, it is our considered opinion that the establishment of university, whether as a minority institution or as a religion-neutral institution of high standard, is a complex and mixed question of law and fact. The legislative intent behind the establishment of university or an institution will have a significant role in determining the status of such institution. For instance, if the preamble or the statement of objects and reasons of a statute explicitly state that the university or the institution concerned is intended to be established and shall be administered by a minority community. We see no reason as to why such a university or institution would be denuded of its minority character merely because it was created through legislative means. Conversely, if the legislature by itself decide to establish an institution where, besides preserving the culture, values, traditions, language, and conventions of a religious or linguistic minority community, it also promotes other streams of education without any barriers to children belonging to other religions. It will be highly debatable to discern whether such a university can take refuge under the protective umbrella of Article 30. Having laid down the broad principles to be followed to determine as to whether AMU qualifies as a minority institution within the meaning of Article 30, we leave it for the regular bench to determine such status in light of the parameters laid down in our opinion. We therefore do not deem it appropriate to express any final view as to whether or not AMU is a minority institution within the meaning of Article 30 of the Constitution. Accordingly, we refrain ourselves from determining the factual issue enumerated as issue number 7 in our judgment. So, ultimate conclusions, thus drawing upon the comprehensive analysis presented in the preceding sections, we thus hold: 1. There is no conflict between 7-judge bench opinion in Kerala Education Bill and the 5-judge council bench in Aziz Basha. The 6th bench in Siddhas Bhai, laying down that the right under Article 30 is absolute and unconditional, is not the correct principle of law. The judgment is no more binding in nature and stands effectively overruled in TMFI to that extent. Consequently, Aziz Basha does not suffer from any legal infirmity on the premise that we do not cite or follow Siddhas Bhai. Third, there is no substantial difference between doubting or disagreeing with the judgment. That being so, the reference by 2-judge bench in Anjuman, doubting the correctness of 5-judge bench in Aziz Basha, and referring to a 7-judge bench suffers from multiple illegalities, including judicial propriety. In view of the dictum of the question bench in Daud Vora, a 2-judge bench has no authority whatsoever to doubt or disagree with the judgment of the larger bench, and directly refer the matter to a bench having a numerically greater strength than the matter so doubted. The reference by the 2-judge bench in Anjuman is nothing but a challenge to the authority of the Chief Justice of India, being the master of the roster, and in derogation of the special powers enjoyed upon under Article 145 of the Constitution, read with the 1966 rules. Consequently, the said reference is not maintainable. However, the subsequent reference dated 12 February 2019, in which the then Honorable Chief Justice of India was the presiding judge, is maintainable. Next, the reference in Anjuman to a 7-judge bench for the reconsideration of the 5-judge bench in Aziz Basha is bad in law and ought to be set aside. Next, the question bench in Aziz Basha, when it holds that Section 6 of AMU Act 1920 stipulates that degree conferred by AMU would be recognized by the government, it could not have been brought into existence by a private individual or body, is seemingly incorrect. Accordingly, and for this reason, and for the reasons assigned in paragraphs 190 B and C, the said decision to that extent is hereby modified and clarified. Further, the minority institutions established in the pre-constitutional era are also entitled to the protection conferred by Article 30. Next, education institutions with reference to Article 30 include universities as well. Next, in order to seek protection of Article 30 of our Constitution, the minority institution must satisfy the conjunctive test, namely that it was established by a minority community and has been and is being administered by such a community. The true import and meaning of the expressions established and administered, which comprise the very core of Article 30, are to be construed and understood strictly in accordance with the indicia in paragraphs 141 and 181. The question pertaining to whether AMU satisfied the above mentioned test of established and administered so as to seek protection of Article 30 of the Constitution, and which will concomitantly entail a mixed question of facts and law, will be determined by regular bench. Thank you.
On this day, personally, I would have been delighted if all 7 of us could have spoken in the same voice. Today's split verdict highlights the diversity in perspectives and interpretations of judges. Since judicial opinions vary based on individual differences, I find myself in the trio of minority. And interstate the minority, I am again in the minority. We have all been discussing about minority, and today, no one other than me characterizes minority best. I will not read the entire opinion. I'll read only paragraph 1 and the last paragraph. And in between, I will highlight what has been held by me. I have started by saying, there is a saying, the past refuses to lie buried. Possibly no other case would demonstrate the validity of this statement more poignantly. Having perused the records, I found that the order of reference of the three-judge bench in 2019 had its roots in the order of 1981, Anjuman. So I have referred to Anjuman as the reference order. I have referred to Aligarh Muslim University as the re-reference order. Anjuman order, a bench of 2 judges directly referred the issue to a 7-judge bench. The majority opinion is that such a course of action is permissible and within the parameters of Dawoodi Bohra. I have referred to several other decisions which have laid down the procedure when a 2-judge bench, even in case of doubt, cannot refer the matter other than to a 3-judge bench. A dangerous precedent is being set. A 2-judge bench tomorrow may say, I doubt the basic structure. I refer it to a 15-judge bench. And this is what exactly would happen if we accept the majority opinion as the final opinion. Of course, it's the final opinion. Can it be done? Are we not in the process overruling Lala Shri Bhagwan, Chief Justice Gajendra Gadkar's judgment of 1967, Pradeep Chandra Parija, Hansoli Devi, Dawoodi Bohra, and again in recent times, campaign for judicial accountability? I have held the reference order to be totally non-est. I've also examined the 3-judge bench order of 2019. I need not elaborate here for the detailed reasons. I've also held that order to be non-est. The references were therefore unnecessary. These are all technical points. I have thereafter gone into merits and said the observation in Anjuman that there is no clear decision on the point as to whether a minority institution can be established with the aid of even non-minorities. There is no clear decision. Very Mother Provincial directly answered that in 1970, which the bench in 1981 was not referred to by the very set of very learned senior counsel who appeared before the bench. This has also not been noticed in the 3-judge bench order. So far as the 3-judge bench order on merits, let me say this. The 3-judge bench noticed that TMFI did not consider 3A, but the 3-judge bench did not notice that TMFI was followed by Islamic Academy, 5-judge, and PA Inamdar, 7-judge. These 2 constitution benches were constituted for the purpose of ironing out the creases flowing from TMFI. They did not consider it necessary to lay down what the indicia is. Even the regular bench to which the matter was referred did not answer it. So today, by laying down indicia, we are discrediting the judges who have adorned the bench of this court right from 1950. It was an implied indicia that they had applied. I have said, if it is necessary to lay down an express indicia, it has to be prospective, not retrospective. Thereafter, I have looked into the enactment of 1920. I have traced the history, and ultimately, paragraph 150, I have concluded that in terms of clause 5 of Article 145, it is my firm opinion that not only do the references do not require an answer, it is also declared that AMU is not a minority educational institution and that the appeal seeking minority status for it should fail. Before parting, I have expressed my sincere appreciation for the members of the bar who have addressed this bench. Listening to their erudite arguments was indeed enriching. I've expressed gratefulness to my research associates who worked tirelessly and burned the midnight oil to help me win the race against time. The scholarly contributions in books and treatises which were consulted, as well as the artificial intelligence systems now available, which have opened up a whole new world, did provide me with valuable guidance and inputs. Lastly, the assistance and cooperation received from this court's library also significantly enhanced my work and made my opinion richer. I regret my inability to acknowledge the contributors individually. That is my opinion.
I've had the privilege and the honor of perusing the erudite and illuminating opinions authored by Honorable Chief Justice Dr. D.Y. Chandrachud and Honorable Justice Surikant. Considering that the present matter involved fundamental questions concerning interpretation of the constitutional provisions and the judgments rendered by this court, I find it necessary to render the present opinion. I would like to make it very clear that my judgment is neither assenting nor dissenting judgment. It's my personal opinion based upon the law, the judgment cited, and the arguments and the facts on the subject. I'll straight away come to the conclusion part. In light of the above, the following conclusions can be recorded. The bench of two judges in writ petition number 54-51 of 1981, titled Anjuman-e-Rahmaniya and others versus District Inspector of School and others, could not have referred the matter to a bench of 7 judges directly without the Honorable Chief Justice of India being a part of the bench. The establishment of an institution by the minority is necessary for the said minority to claim right of administration under Article 30. The words establish and administer are used conjunctively in Article 30 of the Constitution. The term establish in Article 30 means to bring into existence or to create, and cannot be conflated with the generic phrase such as genesis of the institution or the founding moment of the institution. The real positive indicia for determining the question of establishment of an institution would have to be developed on a case-to-case basis on the following broad parameters in mind. 1. Firstly, to claim establishment, the minority community must actually and tangibly bring the entirety of the institution into existence. The role played by the minority community must be predominant, in fact, almost complete to the point of exclusion of all other forces. The indicia, which may be illustrative and exhaustive in this regard, may be the nature of the institution, the legal/statutory basis required for establishing the institution, whether the establishment required any negotiations with outside forces, the role in acquiring lands, obtaining funds, constructing buildings, and other related matters must have been held completely by the minority community. Similarly, while teachers, curriculum, medium of instructions, etc., can be on secular lines, however, the decision-making authority regarding hiring teachers, curriculum, decisions, medium of instruction, admission criteria, and similar matters must be the minority community. The choice of having secular education in the institution must be made expressly by the minority community, demonstrating the link between institution and the persons claiming to establish it. Secondly, the purpose of the institution must have been to predominantly serve the interests of the minority community or the sole betterment of the minority community, irrespective of the form of education provided and the mode of admission adopted. Therefore, as per the choice of the minority community, an institution may have secular education, but such secular education and the resultant institution must be predominantly meant for the overall betterment of the minority community. Thirdly, the institution must be predominantly administered as a minority institution with the actual functional, executive, and policy administration vested with the minority. The minority community should determine the selection, removal criteria, and the procedures for hiring teachers, teaching, administrative staff, and the personnel. The authority to hire and fire staff must be from the minority community. Further, even if teaching or administrative staff may include non-minority persons, the final authority exercising functional, directional, and policy control over these authorities must be from the minority community. This ensures that the thoughts, beliefs, and ideas of the minority community regarding administration are implemented in reality. This represents the real decision-making authority of the institution being of the minority community. In ascertaining the above, it would be open for the court to look at the true purpose behind each of the above factors and to pierce the veil. Aziz Basha categorically prohibits minority from establishing universities due to statutory requirement is unfounded. The bench in Aziz Basha and the present bench are faced with a unique situation and needs to adopt a suitably modulated approach. The judgment in Aziz Basha does not preclude minorities from establishing universities, but rather highlights the importance of legislative intent and the statutory provisions in determining an institution's character. Fifth, the minority community may conceptualize the idea of an institution and may advocate for the same. However, if during the exchange of negotiation, the actual institution which was established had primacy of governmental efforts and control, then such institution cannot be held to be predominantly established by the efforts and actions of the minority community. In the independence and pre-UGC era, in the absence of a provision like Section 23 of the UGC Act 1956, it was open for any institutions to adopt the titles such as university or in some cases Vidyapeeth or Jamia, asserting their capability to grant degrees. The absence of a legislative embargo from private establishment of universities prior to 1956 would be critical for the scope of inquiry. The use of the phrase establish and incorporate by the legislature may be relevant in larger inquiry, but cannot be said to be conclusively determinative of the factor of establishment or not by the minority community. If the intention of the legislature is to establish or incorporate or recognize a minority university, the legislatures have incorporated suitable provisions to color the university with a minority identity. There were no rights, fundamental or otherwise, prior to the constitution coming into force, and therefore there's no question of surrendering any right. The British Indian government was a supreme imperial power in the country, and the question of surrender is illusionary and does not arise in the present case. The coming into force of the constitution and the fundamental rights after 1950 cannot alter the events that occurred during the decade of 1910-1920, which led to the establishment of AMU. There's no legal requirement for the AMU code to be manned by the people from minority community ever since 1951. And therefore, merely because de facto, the persons from the minority community may have manned the post in the institution would not be relevant to adjudicate the question. The assertion that neutral institutions or non-minority institutions would, in the natural course of things of majoritarian, or that Article 30 contemplates constitutionally protecting certain educational spaces from such majoritarianism by default tendencies is wholly erroneous. The purpose of Article 30 is not to create minority-only ghettos, rather provide positive rights to the minorities to establish educational institutions of their choice and kind. Article 30, as a feature of the Constitution, provides important rights which function within the larger penumbra of fundamental rights. There is substantial interplay, intermixing, and balancing of rights intercede with the fundamental rights, and Article 30 is not absolute and certainly do not exist in silo. The crux of Article 30 within bracket 1 lies in its mandate to ensure parity between non-minority institutions and minority institutions. Its fundamental aim is to prevent any form of discrimination or preferential treatment to non-minority communities, thereby advocating for equal treatment under the law for one and all. The provision underscores that no specific category or type of institution should be disadvantaged or unduly favored over another within the legal framework. To assume that minorities of the country require some safe haven for attaining education and knowledge is wholly incorrect. The minorities of the country have not just joined the mainstream, but comprise an important facet of the mainstream itself. The institutions of national character of the country always serve the interests of the minorities and are diverse centers of learning. The UGC Act or the judgment in Yashpal is in no manner comes to the aid of the parties challenging the correctness of judgment in Ajiz Basha. The amendment in NC-EMI Act does not come to the aid of the parties questioning the correctness of the decision in Ajiz Basha. The reference is answered in above terms. The matter be placed before an appropriate bench as per the prevailing rules.
Obliged to your lordship.
Grateful to the court.
Thank you.